We're just watching a replay of the prosecution's expert on cell phone forensic testimony. That was Michael Frizzle. Now, he testified a couple of days ago regarding the locations of the cell phones, talking about the cell phone pings of Zach Adams, Jason Autry, all of the players in this case, as well as Holly Bobo. Obviously, that testimony by the prosecution witness from the Tennessee Bureau of Investigation differs significantly from what we heard today just before the lunch break from the defense cell phone expert. Now, we haven't finished the testimony of the defense cell phone expert. We anticipate that he will be back on the stand after the lunch break. Of course, the direct examination continues, but there will be a chance for the defense to, or for the prosecution, to cross the defense expert. So there's a lot of issues at play here, especially when it comes to expert testimony and how that works with a jury, because you have two people who have shown their credentials, who have shown that they are able to be called experts for the purposes of testifying in a courtroom, and they have differing accounts of what they see from the record. So that is always interesting, the way that a jury takes that in and who a jury finds to be credible at the end of the day. In the law, we always call it the battle of the experts. It's kind of a textbook case of an issue that happens during trial. And to discuss this further, we have the perfect person. We have Stephen Mulroy. He's a professor at the University of Memphis Law School. Stephen, thank you so much for joining us today.
Oh, thank you for having me, Misty.
Well, I'm sure in one of your classes, you have discussed many times the battle of the experts and how that plays out at trial. So as we just saw right before the lunch break, we saw the defense expert on the stand, and a lot of the testimony that we saw so far was really laying the foundation for what we can anticipate is to come. But even in that limited amount of substantive testimony that we've seen, it's pretty clear where the defense is headed. It looks like this defense expert is going to be establishing that during some of these critical time periods where we're trying to establish that the defendant was in the same vicinity as Holly Bobo, the expert's simply going to say that that is not the case. Now, a lot of issues here. There's a lot of dips in service. This is a rural area. In some instances, both experts conceded that they weren't able to actually track the locations. So, Stephen, can you give us a little bit of insight as to how this plays out with a jury? Because now we have two competing experts. Prosecution expert says, hey, the cell phones were in the same vicinity. Defense expert looks like they're going to say the opposite. What does this mean for the jury?
Well, Misty, you're absolutely right. This kind of thing comes up all the time, and we do call it the battle of the experts, and I teach my criminal law students about this as well. In a situation like this, it's going to be up to the jury to decide. Now, if you've got two seemingly competent experts saying diametrically opposed things, the jury's going to have to decide which one they believe. Now, very often, the answer about the merits boils down to a lot of technical details that may be over the heads of some jurors. So as a practical matter, sometimes just the juror's general impression of, does the witness seem confident? Do they project themselves with an air of confidence? Is there anything about the witness that makes them think they're a bit shady and they're not quite telling the truth, or they've got a bias, a motive to shade the truth in one direction or other? That'll end up deciding things. Now, as a theoretical matter, if the two were to cancel each other out, then the tie is supposed to go to the defendant because the prosecution has the burden of proof. But in actual jury situations, it could just be that the expert that seems to be more confident and seems to be more persuasive to the jury will be the one that carries the day.
And you're absolutely right about that, Stephen. And that can often be one of the issues when you're presenting expert testimony to a jury, is that oftentimes it is very technical, especially in this case when you're talking about the cell phone. You're talking about different areas, different zones, different locations. They're all encoded by different numbers, these serial numbers that really don't seem to make sense objectively. They only make sense in the context of the testimony. So that can be really tough to parse through. Also, you have the cell phone pings. What towers are the pings hitting? And many times you'll see in rebuttal to those to that testimony, that isn't always lock solid within itself, that there's room for error as to actually even collecting that data. So let's talk about the two witnesses that we saw on the stand. So interesting that you brought up a lot of this. It all comes down to credibility. That's what a trial's about, right? At the end of the day, you put the witnesses up and the jury decides who they believe. For the prosecution, you have someone from the Tennessee Bureau of Investigation. So you have somebody that is working with that bureau for the state, as opposed to the defense, who in theory was able to choose an expert. That's a defense expert that they presumably vetted and put on the stand, specifically hired in order to analyze this particular case. So what does that mean as far as credibility of each witness?
Well, so the prosecution on cross-examination, among other things, is clearly going to point out the fact that this expert was handpicked by the defense to make a particular type of case, inquire into how much you're being paid, that the more they work on it, the more they get paid, and, their reputation would be enhanced if they were to get an acquittal as a result of their testimony. On the other hand, the same could be said for the TBI investigator. He is being paid, perhaps not as much, but he is being paid to do his job. And certainly, since he works with a law enforcement agency, it might be considered to be advantageous for him to get a conviction in this case. So I think both lawyers, on each side are going to point this out, and it may end up sort of being just what kind of an impression each expert makes on the jury.
Right. And Stephen, when you're talking about especially the defense expert, because very oftentimes, and we'll see, because I can't make a snap judgment yet because the prosecution has not done their cross-examination as of yet, but many times you'll see that these experts probably have been hired by other people throughout the course of their career. Many times these experts work in it. Yes, they're expert witnesses, trial after trial. How much does it matter that somebody has been an expert for both sides of the coin? So say you have an expert on the stand who's always hired by defendants. Does that negate some of their credibility, or does it not really matter if they've done prosecution and defense cases, so long as they're giving their truthful analysis of the data?
Right. Absolutely, Misty. And actually, you took the words right out of my mouth. The next thing I was going to say is one of the things that will come out on cross-examination is this an expert who only testifies on behalf of defendants and always does the criminal defense side of things? And if that's the case, his testimony will probably not be weighed as much. The ideal expert for a criminal defendant is someone who testifies equally for prosecutors and for defendants, and in this particular case happens to come down on the side of the defense. That really bolsters the credibility. That's the kind of thing that every cross-examination of an expert is going to delve into. Do you always testify for just one side, or do you mix it up?
We'll certainly be seeing that. I'm assuming after the lunch break, hopefully this witness will complete its testimony today so we can see that all unfold in one shot, because as you know, sometimes it is hard to keep up with the expert testimony when it's done over the course of a few days. It can be very difficult to really assess. So another question about experts, and specifically in this area of cell phones. Obviously, we are in a whole new era here when it comes down to technology. And as I'm sure you speak to your students about on a daily basis, it takes a little while for the law to catch up to that technology. But in this particular era, I mean, cell phones. Cell phones are really, almost everybody has a cell phone. Many of these cell phones have the ability to track anywhere that you are. They have video capabilities. They have GPS. They have the type of thing that wasn't available 10 years ago. So the fact that this cell phone data, that there's some dips in the data that even these experts were able to collect based on the fact we're in a rural area. Holly Bobo's cell phone was not as high tech as some of the other cell phones that we've seen previously, in that the GPS factor was not working in the same way that you might see on an iPhone or something like that. So is that going to make a difference that, hey, look, we're answering a lot of questions about where these cell phone pings was, where these people were located, but there's pretty significant periods of time where we simply can't tell, even as experts. What does that mean for the jury?
Well, I think it's an excellent question, Misty. I mean, on the one hand, the fact that there may be gaps because of service connection problems in a rural area, that's something that's familiar to all jurors. As you mentioned, cell phone use is ubiquitous. Everyone's got one now. I'm sure everyone on the jury has cell phone experience, and so they might be somewhat forgiving if there are a few gaps here and there between point A and point B. On the other hand, this technology, as you point out, is still relatively new. The idea of using the pings to track second by second someone's location, it's still somewhat untested. It's still in development, and so the defense may be able to make the point that you really can't tell one way or another. You don't really know for sure because the science hasn't been fully developed and matured yet. And of course, any doubt is resolved in favor of the defendant.
Stephen, you said it. All you've got to do is raise that reasonable doubt, and sometimes even just attacking the technology itself can be a way to do so. But one thing in a case like this, and I know that you've been following this case, there's not a lot of direct forensic evidence. Really, this is a circumstantial case. So as far as this expert testimony is concerned, much of that is going to be accredited by other testimony, other witnesses that are establishing this time frame, whether it be prosecution witnesses or defense witnesses. So if you're going to have someone, a person come on the stand and talk about a time frame that might match up with one of the experts' theories of where the cell phones were and the location, is that going to be what sways the jury at the end of the day?
Well, I do know this, that there may not be direct forensic evidence, but there do seem to be multiple witnesses who claim to have heard the defendant say that he did it, or refer to the fact that he knew where the body was and had, killed the victim. And that's pretty persuasive testimony too. And if you've got the testimony of, say, Mr. Autry, who claims to have worked with the defendant in disposing of the body, that's simple, direct. It's not complicated. Any juror can understand that. That may substitute for the lack of direct forensic evidence and meet the prosecution's burden.
Stephen, you are absolutely on point with that. And I want to discuss a little more about Mr. Autry's testimony, as
Sure.
well as the testimony of Corey Rivers, who was the defendant's cellmate. And as you correctly stated, at some point, Mr. Rivers testified that that the defendant actually told him that he did commit this crime. So we want to get into that. Let's quickly play some of Jason Autry's testimony so we can review some of these critical statements that he made while he was on the stand. And then I want to discuss that issue. What happens when somebody has an immunity deal and they testify on behalf of the prosecution? So stay with us,
Sure.
Mike, or stay with us, Stephen. We'll be right back with you.
In order to do what?
To get
Okay. And did you have,
I did.
process that you wanted to do that one?
I did.
Explain it to the jury.
I enjoyed my DOC maybe was a cocktail of morphine and meth together.
So did you have one of those and didn't have the other?
I had the meth.
So you started making phone calls to Shane Austin and to,
Jack Adams.
all right? At any point in the morning, did you make contact with one of them?
I did.
And did you, which one?
Mr. Adams.
And did he call you or did you call him?
He called me back
Right?
and said that he was busy, that when they got to a location, that he would call me.
Other than telling you he was busy and when he got to a location, he would call you, did you ask him any details about what he meant?
I did not.
Do you have any idea of what time in the morning this was?
It was after 8. Probably 8:40, 8:50 maybe. Somewhere in that time frame.
Well, earlier you said you wanted to kill time until you could make a phone call.
That's correct.
So how late were you wanting to wait before you started calling them?
I made the first phone call. At the river, you can't get a signal. It's pretty tough to get a signal there. It's real low. And then when I come out of the river, I made the first phone call at approximately 8 o'clock besides Palmer's Tool and Die.
So from 8 o'clock until you actually made contact, sometime within the hour, you had called both of them more than once,
Correct.
hadn't gotten a response, and then he finally called you back.
That's correct.
So what did you do after he told you, when I get to the location, I'm busy, when I get to the
When we get to the
location?
location, we'll contact you.
Okay.
I went that general way. I knew that I headed in that direction.
And I'm sorry, nobody here but you knows in what direction you're talking about. I went in that direction.
Well, I left Beaton County, headed toward Decatur County, down Birdsong Road.
And why the Birdsong Road area?
It was the easiest access from where I was to get there. Plus, it would be a delay. I mean, it was just the easiest access to get there from where I was, other than going down the main road.
And did you talk to him again?
I did,
Who?
Mr. Adams.
He call you or did you call him?
I believe he called me.
What did he say?
He said, we're at Cuz's.
What did that mean?
That means that they were at 30 Yellow Springs Road, Shane Austin's house.
Your cousin.
He called him Cuz too.
But that's your cousin.
Correct.
So did you go there?
I did.
How far away were you? How long did it take you to get there?
Probably 20 to 30 minutes.
Did he just say that we are at Cuz's, or did he ask you for something? Or indicate that he wanted you to come there for some reason?
When he called me back, he said, I need to see you, I need your help.
And then told you, is that the first time or the second time? You said you
The
talked.
second time. I talked to him first, and they were busy. The second time, he told me where he was at and he needed my assistance.
And when he said, I need your help, what did you think he meant at that point? What did you think the problem was?
I thought a batch of meth was locked up,
Meaning something in the cooking process was
meaning
going
it had
wrong?
gained moisture and stopped making.
Okay. And so, was that fine with you to go help him with a batch of meth?
I was under that assumption, and it was
Okay. So you headed to Yellow Springs Road?
30 Yellow Springs Road.
Will you, if you're standing on Yellow Springs Road, can you describe for the jury, I guess, the way Shane Austin's house trailer sat? In other words, was the driveway down? Could you see the trailer from the street?
From Yellow Springs Road, say this is Yellow Springs Road, there's a fence, a gate, downhill into a wooded area of pines. The trailer sits approximately 50 yards from the road, 40 yards from the road, somewhere in that, on the left-hand side.
I want you to start at the moment that you pulled into his driveway and tell the jury what happened.
Right now, we were live in the Holly Bobo courtroom all morning. The court is at lunch right now. We're waiting for them to come live back into the courtroom. We'll continue with some expert testimony put on by the defense. The prosecution was on the road for 7 days with 45 witnesses, and then they rested their case. The defense just started their defense yesterday. And in the prosecution's witnesses, we saw some people who, despite the fact that there isn't a lot of forensic evidence, there is some witness testimony that could be very damaging to the defendant. And one of those witnesses is the clip that we just watched right now from the testimony of Jason Autry. Now, in his testimony, he details what he saw that day, and he puts the defendant as the person who pulled the trigger after bringing Holly Bobo's body to the river to dispose of it, and finding out that she was still alive, pulled the trigger and shot her in the head. Jason Autry was a part of this. Actually, he was a pretty classic version of an accessory after the fact, assisting in the disposal and removal of her body from the crime scene location, even by his own testimony. So, Stephen, bring us through this, because this is by far the prosecution's key witness. This is the one person who is really giving those details of what unfolded on that day. But this witness has some form of an immunity deal with the prosecution for his cooperation. Now, oftentimes when someone has a bit of self-interest in telling a story that fits in with the prosecution's theory of the case, juries can be skeptical, and the defense can really play up on that fact.
Oh, absolutely, Misty. It's a common defense tactic, and for good reason, because it can seriously undermine the testimony of a witness. So there are a couple of different types of immunity. There's derivative immunity, or use fruit immunity, which just says, the prosecutor says, if you talk to us, we won't use anything that you say against you, but we might have independent evidence. And then there's transactional immunity, in which they say, if you talk to us, we will agree not to prosecute you for X crime. Maybe we'll prosecute you for some lower crime. Typically what happens in a situation like this is things are held open. If the witness does cooperate and the prosecution's satisfied with what they've done, then they will say, okay, we are going to reduce your sentence, reduce your charge, we'll let you plead to something lower, and we'll agree to a plea deal in which the amount of time you serve is limited. No matter what it is, if they're giving some benefit to the witness for the witness's testimony, the defense is going to point that out and say, you have every motive to lie here. You have every motive to make it look as bad as possible for the defendant, because the worse it looks for the defendant, the better it is for you.
Definitely, and that's what we heard from the defense. We heard the defense say, look, this guy is trying to save himself. That's all he's doing. He's throwing the defendant under the bus because he knows that if he were to move forward, he might be convicted and he might go to prison. So it's much more beneficial for him to tell that story that will fit in with the prosecution's theory of the case. But a few interesting things came out of Autry's testimony that we didn't really know before. So a lot of this case, we got a lot of information from the media before this played out in trial. And to see the facts actually come out during the course of the trial has been really enlightening, because a lot of the facts that we saw prior to, and I shouldn't call them facts, it was just the stories that were coming out about what we knew, was not really fitting together, because this had been such a long investigation. There had been a lot of people that the police had looked into prior to actually indicting anyone. So this was really a long haul, and a lot of the information that came out in the beginning was contradicted by stuff that the police found out later before they actually moved forward with indicting this individual. But one of the things that came out during Autry's testimony was that Holly Bobo's brother was actually involved in drugs with the defendant, that they actually went to the house that day because they wanted to produce some sort of methamphetamine. So for the first time, we're seeing some connection between the defendant and Holly Bobo. Another fact that I thought was really quite stunning to tie this together is the fact that Autry was the one who said that the defendant, actually the final shot was a shot to the head when Holly Bobo was found to still be alive after removing her body. Now that's consistent with the skull they found with the bullet hole. So sometimes this witness testimony, despite the fact that the witness may have some sort of self-serving interest in testifying and in pinning this on the defendant, if there's other consistencies in the case, doesn't that lend credibility to this witness testimony despite that bias that might be there?
Oh, absolutely, Misty. So whenever any jury has to determine the credibility of a witness, someone who's got some sort of a deal, well, that is a strike against that witness on the credibility scale. But on the other side of the scale could be other things. One of them, classically, is witness demeanor. Does the witness appear to present themselves in a consistent way and in a convincing way? It doesn't look, obvious that they're lying. And then the other thing is, as you mentioned, corroboration of their testimony. And that corroboration could come from other witnesses, or it could come from physical evidence. In this case, his testimony that there was a shot to the head is corroborated by the forensic evidence, the bullet hole in the skull that was found. So the more you can add on those things, the more you can shore up the testimony with corroboration, either from other witnesses or from physical evidence, the less it's going to be the case that the mere fact that this person is getting a deal for cooperating with the prosecution is going to destroy their testimony.
And I think that's what you're going to see. The prosecution is going to be talking about some of those issues and wrapping that up with a nice bow at the end when they do their closing arguments. Very oftentimes you get a lot of facts, you get a lot of information as a juror throughout the course of the trial, but sometimes it needs to just be fused together when the prosecution tells that final story. And a lot of that information came from
And as
Autry.
we pointed out earlier, it's not just Mr. Autry. There are multiple witnesses in this case who have testified that they heard the defendant make some sort of admission, some sort of statement indicating a connection to the murder of Holly Bobo. And so, in order for the defense to get an acquittal, they're going to have to convince the jury that each one of those jurors had a motive to lie and is lying.
And you bring up a great point, and this is something I'd also love your input on, that we did hear, and one of the witnesses that you're referring to is Corey Rivers. He was a cellmate of the defendant, and the defendant allegedly told him, look, I did it. Do you think God will forgive me? And he talked a little bit about some facts that maybe a person that was not involved in the death of Holly Bobo wouldn't know during the time that he was in jail. But we all know that there is some skepticism about the jailhouse snitch, because sometimes the jailhouse snitch says something about their cellmate or somebody else that they had a conversation with, looking to maybe strike up, whether it be a deal or better treatment behind bars. We don't know, but that is oftentimes a big sticking point for the defense.
Oh, absolutely. I mean, the jailhouse snitch problem is one that occurs all the time for a prosecutor. Sometimes you have no choice but to put on the stand witnesses who themselves have shady past, criminal convictions, or are in jail at the time of the crime. Does this erode their credibility in the eyes of the jury? Well, absolutely, especially because it seems like not too much of a stretch to think that they may be concocting the story to curry favor with prison authorities or with prosecutors. Again, what the prosecutors maybe have on their side, though, is that it's not just one, but it's multiple different witnesses all testifying to admissions by the defendant. It might be the case that one or two of them may have fabricated the admission in order to gain some sort of favor, but the prosecution will argue it's not likely that all of them did.
Right, and that's another great point that you bring up, Stephen. So there were other witnesses. There were multiple witnesses that also said that the defendant had stated that he committed the crime, had bragged about it in some instances. We know that his ex-girlfriend, in some shocking testimony that came out towards the beginning of this trial, said that he had threatened her, saying, I'm going to tie you up and kill you like Holly Bobo. So there's certainly some consistency there. But a lot of those witnesses, and we kind of had a parade of those witnesses towards the end of the prosecution's case.
Sure.
Every single one had a criminal history. Some of them were incarcerated. How does that play into the jury's determination about their credibility? Because that certainly is a factor as well. Outside of just we've got the jailhouse snitch, we've got the guy with immunity, but now you have a lot of people all with credibility issues.
Right. So if you're a prosecutor, you would prefer to have more than just one person with a potential deal to strike with the prosecution. You'd want multiple. And then the best thing would be to at least have one or two witnesses who weren't in negotiations with the prosecution, who didn't have something to gain, and who didn't even have a criminal conviction in their past. But you take the case that you get, and the defense, of course, is going to make hay with the fact that every single witness for the prosecution that had anything actually damaging were themselves people who had criminal histories. So, how much credibility do you give to them? The prosecution will be able to say, you can pick away at one or two or three witnesses because they had criminal convictions in the past, but we've got so many that the cumulative effect of all of them, even if their credibility is compromised, the cumulative effect of all of them leads to proof beyond a reasonable doubt. And ultimately, of course, as you know, that's going to be for the jury to decide.
Yep, that's the key. What does the jury think about all of this at the end of the day after hearing all of that witness testimony? I have another issue that I would love to address with you, and that's about the defense and how they came right out the gate during their opening statements, and they said that there was another person, and his name is Terry Britt. He was a suspect at the beginning of the case. He had a history of sexual violence. He had been He was known. He had been known on lists, etc., in the community as being somebody with that reputation, and therefore the police went to him. They looked at him right out the gate, and the defense, when they did their opening statement, they said, look, there's this guy that has this history of sexual violence, and the police did not fully vet this person. They did not go the distance in actually conducting that investigation. They kind of gave up on this person who was a viable person who could have committed this crime. So what do you make of that? We heard from Terry Britt. I don't know if that testimony really did any good or bad for anyone, really. It kind of didn't really seem to sway me one way or the other. But what do you think about that issue of if the defense can say, well, it wasn't my guy, but it was somebody else, or there's at least a strong possibility it was somebody else, and therefore there's reasonable doubt about whether or not it was the defendant?
Right. So this is a tried and true tactic, and I don't mean anything pejorative when I say tactic, but a method of the defense. The old TV series, The Practice, used to refer to it as the Plan B defense, which is to suggest that there's some other suspect that actually did the crime that the police just haven't properly investigated. And you may say that in this particular case, maybe your view is that Mr. Britt's testimony didn't create that much doubt. I mean, that's going to be for the jury to decide. But if there is any kind of a credible case at all to suspect that somebody else did it, then the defense will be able to argue, well, that is at least reasonable doubt. It's not the defense's obligation to prove definitively that any one person did it. It's not their job to solve the crime. It's their job to simply suggest that there's enough of a chance that Mr. Britt or somebody else did it that the jurors can entertain a reasonable doubt and therefore must acquit.
And that hits the nail on the head in the sense that the defense isn't obligated to bring up any alternative scenarios or to identify another person who committed the crime. That's simply, as you said, it can be a tactic, or if there is another person who was not necessarily looked at by the police, and that is a way to raise reasonable doubt. Absolutely. In addition to that, what we saw was some testimony by Terry Dykes. Now, he is a former TBI agent, and he came on the stand and said that when he first started conducting the investigation, his conclusion was that the defendant could not have been involved in this killing. Now, subsequently, he was taken off the investigation. He's no longer with the TBI. The circumstances behind his termination is opined to be related to his investigation of this case. But if you're a defense attorney, and I'm putting on my defense hat now, and you have the testimony of someone from the TBI who says, look, this person, my conclusion was this person was not a part of this murder, and you have another viable person that you can point to who you can say, look, it's just as likely that this person might have committed the crime. The police just didn't do their job and look into him appropriately. That could really be enough to raise that doubt, especially when you don't have the weapon, you don't have the forensics behind the case as a prosecutor.
Most defense lawyers would not have that embarrassment of riches before them. To have a former law enforcement official who was involved initially in the investigation to come on the stand and say that based on their part of the investigation, they thought that the defendant did not do it, and then add that to have a at least somewhat superficially plausible alternative suspect that you can offer to the jurors in a case where you don't have direct forensic evidence. I mean, most defense lawyers do not have that much to work with, so that is something, certainly a plus on the side for the defense.
So, Stephen, now we've kind of gone through, there's a lot of issues in this case. Obviously, whenever you don't have that direct forensic tie and you're talking more about witness testimony, circumstantial evidence, expert testimony to tie the defendant into this case, what do you anticipate we see next from the defense? Now, we know we have the expert coming back on the stand. We may see more witnesses who are going to testify about the defendant himself, maybe his whereabouts, his location. We know that the ex-girlfriend was not a great witness for the defense. However, I kind of came up with a thought that if he was saying, I'm going to treat you the way I treated Holly Bobo, I'm going to do this, that Holly Bobo was such a big case in that area at the time that you wouldn't necessarily have to be involved in her disappearance or her murder to say something like that. So maybe we'll
If
hear that from the
if
defense.
you were the kind of emotionally manipulative boyfriend who would want to use intimidation to bring your girlfriend into line, you know, you could imagine a scenario in which you would claim falsely to have killed Holly Bobo to scare the girlfriend and bring her into line. And Holly Bobo, as you know, has been a famous case for a long time. Everybody in these parts knows about Holly Bobo. So it's not inconceivable that he could be making it up. Now, it doesn't make him a very good boyfriend. It doesn't make him a very nice person, but it doesn't necessarily make him guilty of first-degree murder.
Yes, Stephen, and I think that we will definitely see the defense attorneys making that point during their closing arguments, and I hope you'll join us as the trial continues with some of your insights on the way that this is playing out in the courtroom. We're still waiting for Holly Bobo to come back from lunch in the courtroom, but right now we're live in the Morris case in Arizona, so we're going to go to that courtroom now.